Hello and welcome everybody. Welcome to another Lawdit podcast. My name is Lora Krastiva. I'm a trainee solicitor here at Lawdit, and I am joined by Izaz Ali, a solicitor, advocate and founder of the firm. Hi Izaz, how are you today?
Hi Laura, yes, all well, thank you.
Brilliant. So actually today, Izaz, you don't know the topic of our podcast. What I'm going to do is I'm going to be asking you questions from a litigation perspective, as if I were a potential client, and you could just talk me through some basics, just because I think there's a lot of misconception when we have clients on board and they think they can just jump straight to a claim, when in fact that's not always, court's not the first port of call, should we
Correct,
say.
yeah, absolutely, absolutely.
So just for these purposes, I'm going to pretend and say, hi Izaz, I'm a client. I think I've got a pretty good chance of being successful in court. Can we please get ready and file a claim? What's the first step to going to court? Basically, I want to go to court.
Okay, so very broad and wide-ranging question. The first port of call is to gather information and evidence, and that's what we would need to understand the basis of what the complaint is and the nature of the case. And then we would start off by reviewing the information and then giving you some guidance as to what the case is, about what your end goal is, and would need to devise a strategy to effectively get you to that end goal. And then moving on from that, we would then need to draft a letter, and we refer to that as a letter before action. And that letter would be sent to the counterpart to set out the basis of your claim. It's a really, really important step. Under the civil procedure rules, you are required to do that. And it's got to be set out in sufficient detail to establish the nature of your complaint, the nature of your claim, what you are seeking in terms of redress, and you've got to allow them a time frame for them to actually address those concerns that you've raised. Now, under the civil procedure rules, there's different protocols that apply. So depending on the nature of the case, you need to double check whether one of the protocols would apply. For example, there's protocols in relation to personal injury claims. So if someone suffered a slip, trip, fall, there's protocols to follow in relation to that, and you would have to follow those. Otherwise, there'll be consequences being awarded against you for failure to do so. Another protocol to follow would be in relation to constructive disputes, to do with construction and builders and the like. So there's various aspects of it, but as I said, first port of call would have to be a letter before action to give the other side sufficient time to respond. And again, outside of a protocol, 14 days, 21 days would be sufficient. Mm-hmm. And if the other side wanted an extension, to consider the information presented or to gather some further information in order to respond accordingly, you ought to allow some further reasonable time for them to do so.
Thank you so much, Izaz. Yes, I think I did throw you a bit in the deep end there with a very, very broad question, but I think that information was very useful, and that is actually what I was getting to without making it too clear, is actually the letter of claim part, which is something that can be overlooked because court is kind of, what we imagine and what we potentially see on TV shows as being the thing that you go to, and actually it's not always the first port of call. It's under the civil procedure rules. You must attempt to solve the matter outside of court, as to not be wasting the court's time. If you take something to court that doesn't need to be there, you're going to get in trouble, aren't you? So yes, I think, and as you covered there as well about the different causes of actions that you could pursue, and you would need to base your letter of claim on, different civil procedure rules to follow, whether it's a breach of contract claim or harassment claim, defamation, negligence, personal injury, all different types of causes of action that can be followed, and different things that can be included in the letter. But just some of the basics is, as I thought we could just shout at the mic things that you do need to include. For example, if I say that you've said about including, we need to include a paragraph stating that this is a letter before claim pursuant to the civil procedure rules of personal injury, should we say. And if I say that we've got to also include a paragraph, in most cases we need to include a paragraph suggesting alternative dispute resolution.
Yes, very, very important. I think the alternative dispute resolution ought to be set out in the form of a separate letter. I'm a great fan of that. I think it's important right at the outset to set that out. Also to consider right at the outset a without prejudice offer. So before costs start escalating, that the parties are aware that this is the nature of their complaint and this is what they're seeking from us if they do seek redress through the courts. However, they've given us a without prejudice offer, and in the without prejudice offer, they're offering us this much money to say that if you were to pay that, then we're happy to sort of draw a line on it now at this stage. So I think that's an important aspect of it,
yes.
Right at these sort of early initial stages. And don't forget, in terms of making a good, well thought out, without prejudice offer, you can only do that if you've really studied the case, gone through all the evidence, and completely understand where your position in the litigation lies. And that's on the assumption of all the documentation that you've been provided without getting a defence in from the other side or a counterclaim. So it's important to get those sort of aspects ironed out right at the start, and then it stands you in good stead for the future.
Yes, thank you. I agree. That's very important. Just some other things to throw at the listeners. We would want to also in a letter include, as Izaz already mentioned, the background of the case, why we're looking to pursue a claim. We've already said alternative dispute resolution, give a deadline, the documents that we would also be relying on. So all of these things are important to include in the letter. And this is just to put a disclaimer in there that this is just kind of general advice, and it's going to be a lot more tailored to each different case, which is important to note. So this is just kind of generic, and there is a lot more to cover. And I did ask Izaz a very, very open question there at the start, but we've kept to a very small part of what can be a very long route to potentially taking something to court, but it's always going to be the first step that we need to consider. So yes, I trust that we would also explore the later stages in later podcasts, but that's it, I believe, for today. Thank you very much, Izaz, for joining me, and we'll be back again soon with another podcast.